I am not going to speak to you this morning about the accepted and well-documented consequences of corruption. These are almost trite. After Derek Murray invited me to participate in this conference, I thought that I should focus my address not on Barbados, but rather on some islands in the northern Caribbean, which those of us who live in this part of the region hear about every time we are on a flight to Miami. The captain will say that our route today takes us over the Turks and Caicos Islands. But I'm not sure that many of us have any acquaintance with the Turks and Caicos Islands. But there are some important lessons from those islands that I wish to share with you this morning. So accordingly, I wish to give you some insights into the role and function of the Integrity Commission of the Turks and Caicos Islands, which I've had the honor and privilege to chair for the last 4 years. I trust that you may find them instructive and relevant to today's theme and the content of your discussions. Now, I've structured this presentation under 5 broad heads. First, I give you a short historical background to the establishment of the Integrity Commission. Secondly, I shall deal with the main features of the original legislation, and I emphasize original because that legislation was amended in 2012. But the original legislation which established the Integrity Commission, that is to say the Integrity Commission Ordinance of 2008. Thirdly, I will tell you about some legislative expansions in the functions of the Commission to include, I believe, which are relevant to you, the registration and financial operations of political parties and the regulation of election campaign financing. Fourthly, I shall address the Commission's experience of regulating political parties and election campaign financing. And I will then make some observations in conclusion. Now, as you may know, the territory of the Turks and Caicos Islands, which I will call and abbreviate as TCI, is one of 14 United Kingdom overseas territories. It consists of an archipelago of small islands south of the Bahamas chain and about 612 miles southeast of Miami and 90 miles north of Haiti and the Dominican Republic. The territory comprises some 40 islands and cays. The whole land area is quite small, it's about 190 square miles, with a total population of 36,000, and I exclude the several thousand illegal Haitian immigrants. And on many of the islands, there are high-quality tourist developments and expensive private homes. The islands are not constitutionally part of the United Kingdom, but they have enjoyed varying degrees of self-government over the years, subject, of course, to the oversight of the United Kingdom exercised through a governor. The TCI have their own constitution by virtue of an order in council made on the 13th of July 2011. The governor acts in consultation with the cabinet, but certain matters such as defense and external affairs and regulation of international financial services are reserved to the governor. There are two main political parties, the Progressive National Party, PNP, and the People's Democratic Movement, PDM. Although in the 2012 elections there were three, but generally, customarily, there have been two. Now, since 1976, there have been a series of commissions of inquiry made necessary because of serious concerns about the quality of governance in the TCI. In April 1986, for example, Sir Louis Blum Cooper found that the chief minister and two other ministers had been guilty of unconstitutional behavior and ministerial malpractice. He did not find corruption, but he observed, and I quote, this is what he said, "I cannot simulate deafness to the voices of responsible people in the islands who complain that there is pervasive corruption of government. If only it could be uncovered by diligent and sustained inquiry over a number of areas of governmental administration," unquote. Now, soon after Sir Louis handed in his report in 1986, July, the Constitution was amended to suspend ministerial government temporarily. Sir Roy Marshall, very famous Barbadian lawyer who was also Vice Chancellor of the University of the West Indies, among other things, he headed a commission to inquire, to consider possible future amendments to the Constitution, and the Marshall Commission's report was published in December 1986, and that paved the way for a new Constitution in 1988 and the restoration of ministerial government. In the meantime, in 2006, a new Constitution was enacted, revoking the Constitution of 1988, but the Constitution of 2006 barely lasted 5 years. On the economic front, between 2000 and 2008, the TCI experienced growth which was, and I quote, rated among the highest in the world, unquote, because there was considerable overseas investment. And in the words of the Right Honorable Sir Robin Orr, retired Court of Appeal judge of England and Wales, who conducted an inquiry, which I'll tell you about shortly. Sir Robin alluded to that investment and said that much of it was, quote, hungry for crown land at the disposal of the governor in cabinet, and brought with it continued governmental maladministration and a mix of incompetence and perceived corruption in public officers, whichever of the two political parties was in power, unquote. And he observed, and I quote again, "There is nothing new about allegations of governmental incompetence and abuse of power in the TCA," unquote. So that by February 2007, you had an economy which was booming, and the government, the PNP, won a handsome election victory. But the island's public finances and their management attracted trenchant criticism. When the global economic recession hit in 2008, the former buoyant sources of revenue diminished. The diminution was not matched by a reduction in extravagant spending by ministers on various projects and on themselves. And those last few words are also Sir Robin Orr's. So at the end of the fiscal year 2007-2008, the public deficit of the TCI was $38 million US. United Kingdom's Foreign Affairs Committee took note and investigated. It received a plethora of prima facie evidence of large-scale corruption among the political class and voted in favor of an inquiry. Within a month of the publication of the UK Foreign Affairs Committee report, the governor established a commission of inquiry on the 10th of July 2008, and Sir Robin Hall was appointed to conduct that inquiry. And he was asked to inquire into whether there is information that corruption or other serious dishonesty in relation to past and present elected members of the TCA House of Assembly may have taken place in recent years. A very wide remit. He was also mandated, like all commissions of inquiry, to make findings and recommendations, and to make findings, importantly, concerning the instigation of criminal investigations by the police or otherwise. Now, without dilating upon the several findings of Sir Robin, I am content merely to say that his report was a stinging indictment of the Premier and several ministers. You may have heard the name Michael Mizzy. He was the Premier. Lord Justice Hall, at page 116 of his report, described the conduct of the Premier in this way, and I quote, bring a long story short, the Premier, Mr. Mizzy, 4 ministers, and a number of other persons, including lawyers and private sector investors, have subsequently been charged before the courts criminally. With respect to the governance of the TCI, the All Commission recommended, inter alia, cessation of ministerial government, dissolution of the House of Assembly, and direct rule by the governor, assisted by an advisory council. And the report of the Lord Justice Hall was submitted on the 31st of May 2009, and his recommendations were swiftly implemented. The British government took back the governance of the islands from the local people, and all I can say is that the stench of corruption was overpowering. It was in those circumstances, and against the background of the All Commission report, that a new Constitution of 2011 and the Integrity Commission came into being. I said it came into being because in 2008, legislation had actually been passed establishing an Integrity Commission, but it never came into force. Sometime after I retired, I think it would have been in March, I retired officially April, but it was known in January that I was going to retire. But I got a call one Saturday from the Governor, Gordon Weather, asking me if I would come and set up this commission for him. So we talked about it. Anyhow, eventually accepted. And the commission came into force in May 2010. We had a legislation from 2008, but it was not activated, promulgated until 2010. So broadly, our mandate is to promote and secure the integrity of persons in public life in the TCA. And persons in public life include, as a list in the schedule to our ordinance, the Deputy Governor, members of the Integrity Commission themselves. We have to fill up the forms of declaration of assets and liabilities and so on. Members of the House of Assembly, permanent secretaries, heads of the department, and senior officials in a variety of statutory bodies. The legislation, which they call an ordinance. The ordinance itself is a contemporary and comprehensive piece of legislation, drawing upon models existing elsewhere in the world, notably Hong Kong, and the Integrity Commission is enshrined now in the Constitution of the Turks and Caicos Islands as one of the institutions said to be protective of good governance. And the functions of the Commission are similar to those of the Integrity Commission in Trinidad and Tobago. That is to say, to receive and keep on record all declarations forwarded by persons in public life, the income, assets, liabilities of those persons, their spouses, and dependent children have to be declared every 2 years. We have to examine those declarations and request further information if necessary. We can conduct inquiries and investigate in order to verify or determine the accuracy of declaration, and receive and investigate complaints regarding corruption, investigate allegations of corruption either by whistleblowing or our own motion. We examine the practices and procedures of public bodies to enable us to detect corruption, and we advise and assist management of public bodies of any changes in their practices and procedures which third, the responsibility of the Commission is the promotion of integrity, honesty, and good faith in the Turks and Caicos Islands. He is bringing me into land in 10 minutes. The ordinance creates a variety of acts which are deemed to be corrupt, but these are specific to the ordinance, but in addition to the ordinary criminal laws which may otherwise provide for corruption. Unlike any other anti-corruption agency in the Caribbean, the Commission enjoys some unique features which I will mention. Constitutional protection and independence. Constitutional protection of its funding and operational independence. And executive powers which enable the Commission to investigate, arrest, and charge persons for corruption. And currently there are quite a number before the court, the most renowned of which is the Deputy Commissioner of Police. Now, those were all part of our original mandate. But then, in 2012, we found our responsibilities expanded by the Constitution and a new law, a new ordinance which may be of some interest to you. It is called the Political Activities Ordinance 2012. In anticipation of new general elections to return the islands to ministerial government, and following the recommendations of the All Commission, the British government instructed the governor to prepare legislation to regulate political parties and election campaign financing. And this legislation vests the responsibility for those matters in the Integrity Commission, which I chair. So we have these new aspects of our mandate. General elections came in November 2012, and by reason of this expanded mandate, the Commission played a pivotal role in those elections. So let me just tell you, give you a little flavor of the kinds of matters that are provided for. In the ordinance, which came into force in August 2012, it is stated that its objective is to ensure greater accountability from political parties. Now, it is based upon a UK statute called Political Parties, Elections and Referendum Act 2000, and is the first enactment of its kind anywhere in the Caribbean. This ordinance provides for the registration of political parties and their office holders with the Commission. Part 3 enacts accounting requirements for registered parties. Political parties are under a legal duty to keep accounting records showing, for example, from day to day, all sums of money received and expended by the party and the details of income and expenditure. We determine the financial year of a registered party, and we set it in the traditional mode, April 1st to March 31st. And the treasurer of the party under the law must have accounts prepared for each financial year. And where a party's gross income or total expenditure in a financial year exceeds $500,000, the accounts must be audited by a qualified auditor. Now, there is provision for the Commission in certain cases to make copies of statements of account available for public inspection. Part 4 of the Political Activities Ordinance seeks to control donations made to political parties. Donations include gifts of money or property, sponsorship, subscriptions to the party, money spent in paying party expenses, money lent to the party otherwise than on commercial terms, and all of these things are defined in the legislation. Now, with a view to ensuring that political parties receive only legitimate or clean donations, there are restrictions upon the kinds of donations which parties can receive. For example, a party cannot accept donations if the identity of the donor cannot be ascertained, or if it is suspected that the donation represents the proceeds of unlawful activity. And the maximum permitted donation, we're talking about small jurisdiction, of course, is $30,000. The rules pertaining to donations are very extensive and too time-consuming for me to even attempt to go through them. But I should say that treasurers of political parties must prepare donation reports every 6 months. And during an election period, these reports must be done on a weekly basis and sent to the Commission for entry in our registers. Now, don't mind the 10 minutes, I have to overshoot the runway. I want to touch on campaign financing. As is the case with donations, the provisions relating to campaign expenditure are very detailed and a little bit complex upon a first reading. But they seek to regulate expenses other than those expenses of candidates which are usually included in the ordinary return of a candidate at election time. These are unusual situations. Because the requirements are detailed and complex, political parties are allowed to appoint persons called deputy treasurers to assist the treasurer. But no campaign expenditure is to be incurred by a political party unless it is authorized by the treasurer or one of the deputies. The ordinance prescribes financial limits to be incurred by or on behalf of a party. And for example, the limit in respect of most electoral districts is $30,000 for each district contested. The party leader's limit is $100,000. And where campaign expenditure exceeds $250,000 for the party, a report must be prepared by a qualified auditor. I need not emphasize that in all of these ordinances about which I've spoken, there are very heavy criminal and civil sanctions for their breach. Now, I've sought to give you a flavor of our attempt to control the financing of election campaigns. My own view is that the legislation imposed from the UK and reflective of UK notions and culture is unnecessarily detailed for the TCI. But having said that, I must confess that it worked extremely well for the 2012 elections. We were able as a commission to implement the ordinance because first we contracted staff who had a familiarity and expertise with that type of legislation. And secondly, we embarked upon a robust campaign of public education, and that involved interfacing with political parties and independent candidates and making guidance notes available to them to help them comply. Before I conclude, I should also let you know that under Section 102 of the Constitution, the Commission has formulated a code of conduct for persons in public life. It is a document of some 53 pages. But at Appendix A are the famous Nolan principles with which I'm sure you are conversant. But for those who are not, they include the 7 principles of public life: selflessness, integrity, objectivity, accountability, openness, honesty, and leadership. And in Appendix B, with the assistance of the Integrity Commission of Trinidad and Tobago, we drafted a guide to assist persons in public life in identifying, avoiding, and managing conflicts of interest. There's also legislation about registration of interest, but I won't go into that now. I wish to conclude and say that what Sir Robin All's Commission of Inquiry showed was that possible corruption on the part of some political figures was the direct consequence of possible corruption by persons in the private sector. And in this regard, I have a personal concern that it does not appear to me, and I may be totally wrong, but it does not appear to me that Transparency International pays enough attention to ferreting out corruption in the private sector. Their focus seems too heavily weighted in favor of the public sector. But in the majority of cases, let us face it, public officials are corrupted by persons in the private sector. The All-Commission report is replete with findings of private sector complicity in possible corrupt behavior on the part of politicians. For example, bear with me, please. He found that the Premier received payments representing finder's fees or commissions from land developers. And this is what Sir Robin wrote. He received millions of dollars in transactions formally documented as loans, one of which was a sum of $6 million on advantageous terms from the overseas backers of a development project on Salt Key. The collateral on the loan was the 50% share in Salt Key Golf Club agreed by Mr. Mario Hoffman, the developer of Salt Key, to a company controlled by the Premier's brother, following the grant of development permission by the Premier himself. Now, for his role in that transaction, Mr. Hoffman faced the likelihood of prosecution, but he settled quickly by paying millions of dollars in compensation to the government. There are others too, including a very famous West Indian. I'm not going to say any more about that now. It's all on the net. My message to you is that if there is the political will, a country can seek to control corruption by the enactment of appropriate legislation. Defeatist attitudes, laissez-faire complacency or we can't do anything about it are attitudes that are contrary to the public interest. The law must seek to prescribe the minimum content of appropriate political conduct to ensure good governance in the best interest of all the people. A small Caribbean jurisdiction has shown that it is possible to seek to regulate the conduct of politicians and public officials by statutory intervention. In particular, where no specific legislative control of election campaign funding exists, this deficiency can be cured by relevant legislation. All countries in the region have legislation which prohibits bribery and treating at elections. This type of legislation is honored in the breach. What is required, in my very humble submission, is stiffer legislation which calls for proper accounting by political parties to restrict the use of political parties as a medium for facilitating corruption in its many guises. Legislation which requires the publication of the amounts of purported donations and the identities of donors and donees goes a long way towards the achievement of good governance. Now, I am not so naive as to believe or suggest that legislation is a panacea. It is not. It is a facilitator and it is a regulator. At the end of the day, it is the personal integrity of politicians and public officials which determines corruptibility or incorruptibility. I am happy to report to you that the Integrity Commission's experience of monitoring, managing, and operating the new legislation in 2012 was entirely satisfactory. One of the remarkable features was that some private sector donors actually wrote to the Commission informing us as to the quantum of their donations to political parties. I'll finish on this note. Based on the returns submitted to the Commission, the three registered parties spent a total of $578,303. Advertising and publicity materials accounted for $236,952, or approximately 41% of total expenditure. And for the three parties, the PDM spent $135,000. The PNP, the party that won, spent $332,000, and the PPP $110,000. I've given you wrong figures. I will end this address by telling you that following the publication of the All report, the TCI's economy went into a sea. Investor confidence and tourism declined. However, since the implementation of the new legislation, since the holding of new general elections, since the return of ministerial government and the settlement of some of the cases like Hoffman and others, the economy has started to grow again. And without being immodest, I believe that the work of the Integrity Commission has also contributed to a feeling that best practices in governance are being pursued vigorously in the TCA, and valiant efforts are being made to securing the international reputation of the TCA as a clean jurisdiction in the future. I'm obliged to you for the privilege of this occasion. Thank you.